Chapter 20, Laws Governing Labor Management Relations. So the learning objectives in this chapter were structure of the primary U.S. labor legislation and the mechanics for its enforcement, labor organizing, the collective bargaining process, and strikes, boycotts, and picketing, global dimensions of labor management relations, legislations governing labor management relations, the Wager Act of 1935, the Taft-Hartley Act of 1947, the Landrum-Griffin Act of 1959. So the Wagner Act, the National Labor Relations Act, is NLRA, guarantees the rights of workers to organize and bargain collectively, forbids employers from engaging in specialized, unfair labor practices, and aims to facilitate and formation of labor unions, settle labor disputes by collective bargaining. And then the Taft-Hartley Act bars unions from engaging in specific unfair labor practices, making collective bargaining agreements enforceable in the U.S. district courts, and provides a civil damages remedy for parties injured by certain prohibited union activities. And then the Landrum-Griffin Act governs the international operation of labor unions, requires financial disclosures by unions, and establishes civil and criminal penalties for financial abuses by union officials. Labor's Bill of Rights provides protection for employees against their own unions. And then the National Labor Relations Board, NLRB, the administrative agency set up to interpret and enforce the Wagner Act, functions monitoring the conduct of the employers and the union during the election, preventing and remedying unfair labor practices, and establishing rules and regulations interpretive the acts. Jurisdiction granted by Congress over any business affecting commerce based on the NRLA. Employees omitted from NLRA coverage, federal, state, and local government employees, employees in the transportation industry, and those covered by the Railway Labor Acts, independent contractors, agricultural workers, and household domestics, persons employed by a spouse or parent, and supervisors, managerial, and confidential employees. Procedures in unfair labor practices cases and initiate by the employee union or employer filing an unfair labor practice charge with the appropriate regional office. The charge is examined by the field examiners, and the regional director determines if its compliance should be issued. An attorney informally tries to resolve issue complaints. Regional office's attorney prosecutes the case before the ALJ if the informal negotiations are unsuccessful. Labor organizing. Dissatisfied employees cannot contract a national union that represents employees engaged in similar type of work. Union sends a representative to explain what unionization can do. If the employees want to pursue a unionization, the organizer helps them run a campaign to convince the workers to accept the union as their exclusive representative. And subjects of collective bargaining. Mandatory subjects over which the party must bargain, rates of pay and wages, hour of employment,